आई होप सबको मेरे स्क्रीन क्लियरली विजिबल होगा, कोई ऑब्स्ट्रक्शन नहीं है, पूरा स्क्रीन देख पा रहे होंगे।
यस।
वेरी क्विकली, ये हमारा, मैं इन चीजों को थोड़ा सा देखना चाहूंगा। आई विल, ओ श्योर। सो बिफोर वी मूव ऑन, कैन एनीबडी टेल मी what we learned yesterday? So you had a good session yesterday regarding interaction, regarding intellectual property. So what is intellectual property? Before we talk about copyright, trademark, patents, trade secrets, and designs. And most of you would also be able to observe, आप ये भी देख पा रहे होंगे कि I am not covering the detailed list of intellectual property as you had seen yesterday. I'm not covering geographical indication. I'm not covering industrial designs, right? But I'm limiting myself, and I'm limiting for the specific purpose, for the reason being that what we will be able to cover from the perspective of cyberspace. So those will not be directly related to cyberspace. We are broadly not covering that. Now, before we move on, very quickly, what is intellectual property? Yes, anyone? Yes.
Sir, intellectual property is a thing or a asset which is created intellectually
Intellectually, okay. Anyone else?
on the
कोई
basis
ऐसी
of
चीज है?
knowledge, experience, on the basis of knowledge, experience, which is useful in the
Okay,
society.
okay, okay.
Sir, it covers the
Yes.
intangible creation like human artillery and literacy work, like anything which is created by human mind. And it basically
Right.
tangible thing. Intangible is that you cannot see, touch, or feel. So basically, we will rely on it
Correct.
in literally and artistic works.
Okay, okay. Yes. Anybody else? Both of you are correct. Both of you are correct. Yes. Anybody else? It's just you are correct, but you're missing on a very important aspect,
Sir,
which I would like to. Yes, yes.
an original creation of human intellect like art or some creation like science, literature, technical, something like technical thing and scientific thing, which is new and which is not created before.
Okay, okay. Yes. Again, we are missing on another very important aspect. You're correct again. You all three of you are correct. One thing is something which you are very missing, which is a very important aspect of any intellectual property.
Sir, trademark.
Yes, yes, trademark. Yes, somebody was speaking about trademark.
You were talking about trademark, copyrights, patent. That is missing. Is that thing?
No, no, it's not. It's not. I'm not looking at something very specific to copyright, trademark, patent, and trade secrets and design.
So
What
innovation?
Innovation. Now, innovation. Do you think there is any innovation in copyright at all, or for that matter, trademark?
Sir, copyright is for any innovation or invention that we have done something unique. So under IP, we have
Whether
just to preserve that thing.
okay, okay, okay. Yes. Anyone else? Right. I think let's not go round and round. Most of you are absolutely correct when you refer to intellectual property as intellectual property is creation of human mind. You are absolutely correct. But every creation of human mind will not be considered as a intangible asset. So you also rightly pointed out. Now, it's not there in the screen. If you're able to see me, my photograph, you see my first hand. Now, this first hand is what? Say for that matter, this is property. Okay. Now, this property can be broadly divided into immovable property or movable property. Okay. I'm sure most of us would have studied a property law or might over a period of time will study law. So property is, as we are able to see, so say for that matter, the chair on which you're sitting, right? The chair on which you're sitting, what is that? It is a property. Now this property is, can you touch it? The answer is yes. Can you move it? The answer is yes. So what kind of property it is? It is a tangible, movable property. Now, similarly, intellectual property, can it be moved? The answer is yes. So is it a movable property? The answer is yes. But can you touch it? The answer is no. But the most important aspect of any asset or any property is commercial exploitation. So any creation of human mind or human creativity which is commercially exploitable will be considered as intellectual property. I hope we are able to understand. So those definitions which I got from all of you, there was very important aspects which you were missing was commercial exploitation. So without any commercial exploitation or without any commercial value, a thing, whether it's tangible or intangible, cannot be considered as an asset, whereas intellectual property is an asset. I hope we are able to get these points. Okay. So what is intellectual property? Intellectual property is plain and simple. It is a intangible property. That's one. It is a creation of human mind or human creativity, which is obviously, could be result of an innovation, certainly, right? Which can be commercially exploited, right? So what is important? Creation of human mind or human creativity, commercially exploitable. When we add these two, it becomes intellectual property. I hope we were able to appreciate that. Now, very quickly, what you are able to see on this slide is broadly 5 different types of intellectual property. Now, these 5 different types of intellectual property, I don't want to go beyond this because it's not very relevant. हमारे लिए वो बहुत useful नहीं होगा. ये 5 वो intellectual property हैं जो cyber space के perspective से हमारे लिए important हो जाते हैं. Now, copyright, as you are able to see, so what you are able to see, the color code you will be able to observe. Right. So somebody is writing on the screen. I am not very sure which student is writing on the screen. Right. But I'm sure we can get it removed. Can we? Anyways, so this is something which we'll have to see. I think it should be one of the. But anyways, somebody has written on the screen, and I would request organizers if they can look into it and get it removed. Anyways, or at least the writing rights from any student may take it away. It's their way. Quickly returning back. So these are the 5 different types of intellectual property. So what does copyright cover? So copyright covers literary. I hope you are able to see at the top, literary. On the right side, literary, dramatic, musical, and artistic work. So literary is something which is written. कोई भी चीज जो लिखित है. Dramatic, resulting out of drama, right? Musical, in form of music. Artistic work like painting, sculpture, all these things. So on all these aspects, you will have copyright. But all this work, in order to get copyright, requires 2 things. One, such a thing, literary, dramatic, artistic, or musical work has to be original work, right? It should not be copied. It has to be original work. Second, it has to be fixed in some form. Fixation. The fixation is a very important aspect of copyright, which sometimes we do miss out, right? So originality and fixation. Now, when we talk about trademark, trademark is nothing, but it's a mark, which may also include shapes, colors. Nowadays, trademark is also covering smell. So that's very interesting. So there are conventional trademarks, there are non-conventional trademarks. So in non-conventional trademarks, even sound and smell are getting trademarked. Okay. So what are these? Trademark are relevant from the perspective of trade. So just to give you a simple example, when you look at an half-eaten apple, which brand does it come? Which brand does come to your mind?
Apple, sir.
Half-eaten apple.
Sir,
Correct.
Apple.
So you are able to relate, commercially that half-eaten apple with the Apple company, right? So the whole idea is, so a mark which is used for the purpose of representing the origin of the goods, right? So when you look at that half-eaten apple, you will always think that this is an Apple brand, laptop or mobile phone and so on. So that is what is trademark. Now, patents is all about innovation. we have been using the word innovation. So innovation as a term is usually which is used in patents. This is something which is very important. And to what do we give patent? We give patent to inventions. So like in copyright, literary, dramatic, musical, and artistic work get copyright. In trademark, what gets trademark? Mark gets trademark. In patents, what gets protected? Inventions get protected. Now, what is invention? So invention is either a product or a process, right? What is invention? Invention is either product or a process which fulfills the three criteria of novelty, innovativeness, and industrial use. Like in copyright, we said literary, dramatic, artistic work. What two things are required? Originality and fixation. Originality and fixation. For mark, what is required? Distinctiveness. That one mark is distinctive from other marks. In invention, what do we get? So what is an invention? It's either a product or a process. Product is, final product. I hope we are able to understand. And a process is the process for making that final product. So that process also can be protected under patents, or the final product could also be protected under patent. What is the requirement in order to protect that product or process? Is a requirement of novelty, innovativeness, and industrial use. Then we have trade secrets. So trade secrets, it's a secret, right? So, secret for what? The secret which your best friend has told you about? No, it's a commercial secret, just like KFC, Coca-Cola. So the formula of Coca-Cola, how many of you know about the formula of Coca-Cola? Anybody knows?
Sir, no, it's patented, so they cannot disclose.
It's not patented, my friend. It's trade secret. It's not patented, it's trade secret. There is a reason why it's not patented. The reason is that the patent protection is just for 20 years. But the Coca-Cola company is for more than 100 years. You're able to understand. So it's not patented, it's a trade secret. Nobody knows the formula. And additionally, when we talk about patents, whatever your invention is, you have to disclose your invention completely to the public. Whereas in trade secret, we don't have to tell any information about the commercial secret we have. So the formula of Coca-Cola or ingredients of the KFC spices, nobody knows. It's a trade secret. But you have to understand it's not patented. So, trade secret is different from patent. Patent is different from trademark. Trademark is different from copyright. And copyright is different from designs. The problem is that sometimes we use these terms interchangeably, which is incorrect. I hope I am able to communicate myself. सब लोग समझ पा रहे हैं मैं क्या कह रहा हूँ? तो इन चीजों को जो बारीकियां है ना, ये हम समझें, ये बहुत इंपॉर्टेंट है, क्योंकि हम ट्रेड सीक्रेट को पेटेंट और पेटेंट को ट्रेड सीक्रेट या पेटेंट को ट्रेडमार्क कहेंगे तो वो सही नहीं है, क्योंकि हम अब ले मैन नहीं है, हम लॉयर्स हैं. ठीक है? सो वी आर प्रोफेशनल्स एंड people come to us because we are professionals, right? So trade secret is nothing, but it's a confidential information. What kind of confidential information? An information which is relating to commercial activity, and you should take some steps to keep that secrecy or protect that secrecy. Then it will be called trade secret. And then finally, designs. Now, there are two types of designs. You would have already studied about industrial designs, and then the second one is semiconductor integrated circuit layout design. Now, industrial designs could be in form of designs of any machine, designs of, say for that matter, any jewelry, or designs of any, it could be any design you would think of, right? But what is relevant for us from the cyberspace perspective is integrated circuit. I hope all of us know what is integrated circuit. So a circuit which is created on a specific board in which we have transistors and capacitors which are put together. So I'm sure some of you might have seen motherboard in your computer, right? Now this motherboard is, is a big integrated circuit in which there are several, small things which are put. What are those things? Those are transistors and capacitors. Now, transistors and capacitors, those who are from electrical engineering background, which I hope Nobody would be from electrical engineering background. So we would not complicate things for ourselves. So just keeping it simple, if we have seen the motherboard of our computer, it's something like an integrated circuit on which the arrangement, how it is being done, that arrangement is what we protect, right? But this protection again is for 15 years. So it's not for very long. So these are the different intellectual properties which are relevant from the perspective of cyberspace. Very quickly, any queries till now? Very good.
I need to
Thank
ask,
you, Kush.
you
Yes.
mentioned trade secret. So there is a body that is World Health Organization or Food Safety and Standard Authority. So will they also not
Correct.
disclose their ingredient to them, because it is also important for them to check and regulate if there is something wrong with the standards?
No, they would not until unless there is some report. So that's a very good question. I'll come back to you, Kushi, for the fixation part. So you're very, very correct. Now, the whole idea is WHO and bodies which are regulating food, they can take the sample of the food, right? And determine whether such food in form of Coca-Cola or KFC chicken is hazardous to health, right? But they cannot, as a matter of right, claim the formula which has been protected since years and which are of commercial value to such companies. I'm not sure who asked the question, but are you able to understand me? So these bodies have nothing to do with the ingredients. What is the final intake a individual is taking? Now, if that final input which an individual is taking is having anything which is harmful to human being, then you can ban such a product. But then as a matter of right, you cannot force a company to disclose their trade secret, which in the form of Coca-Cola formula or KFC, ingredients, spices. I hope we are able to understand. I don't know who asked the question. You will have to, give me feedback.
Sir,
Did we get it on?
case with happened with Nestle Maggie where they identify lead. So, sir,
Correct. So,
if an else,
yes, continue.
if an else same thing happens with a trade secret, so obviously the government will just recognize all the ingredients that they were keeping safe. So don't you think it will be infringement of the trade secret that they have used?
No, what the government can do if somebody is not ready to disclose the details of the formula, the government can ban such product from commercial sale. Just to give you a simple example, you are absolutely correct. The Maggi masala, our lovely and that tasty Maggi masala. So I don't know how many of you understand Ajinomoto, right? Which is carcinogenic. Carcinogenic means it can cause cancer. So there were certain chemicals which were found in the Maggi masala which were carcinogenic, and similarly there were certain products of Nestle. So immediate action was taken. But then you have to understand those formulas or those masalas were not trade secrets. They are accessible to any common man can go and purchase that masala, and the details of their ingredients is provided behind, right? Now you have to understand the companies are not hiding what ingredients they are putting in Coca-Cola. What they are hiding is in what proportion they are putting it. They are clearly providing, they are putting sugar, they are putting water, or you should go back and, purchase Coke. I'm not encouraging anyone to use Coca-Cola or, go for KFC. But you have to understand, these companies are not saying we won't tell what we are putting. But what we will not tell is in what proportions we are putting so that you get that flavor. Now, your mother cooks food for you every day. But does the taste is same every day? The answer is no. Someday it's very tasty, but someday it's not. So possibly one day she put masala in such a way that it gave you a specific result, right? But that is what Coca-Cola is. It's not saying I won't tell what I am putting. It's just I would not tell in what exact proportion I'm putting. That is a trade secret. That is creating a unique taste. And that is not at all creating any harmful effect for the human beings. However, you are absolutely right on the point which you are raising. What for others, let me explain this. What he is raising, there is a public interest, right? Public interest, that is public health for that matter. and there is something what is called commercial interest of a company, which is a private interest. So there is a conflict between the public interest and the private interest. Correct? Public interest of public health, commercial interest of the company. And if there is a conflict between the rights, which right should be given preference? Always the public right will supersede the private right. That is always correct. I hope we are able to understand. So what you're asking is absolutely correct. If ever there is a conflict between a public right and a private right, public interest or public right will supersede the private individual commercial interest of a private individual interest. Always, always and always. Right? But then at the same time, you cannot force any commercial entity to stop earning interest or profits. Right? Why you drink Coca-Cola and not any other drink? Why you don't prefer the cola made by your mother at home, but you prefer Coca-Cola? You should not have either of them, but yes. I hope I have responded. Very quickly, and if there is any supplementary or further question, you can ask. Now, Khushi, you there with me? Khushi Tayal. Khushi Tayal? You can respond in the chat box also, because she has asked a question. Sir, can you explain the meaning of fixation here? So I just wanted that she's listening because she has specifically asked the question. So I want to, fixation simplistically means, just to give you an example, all of you heard when this meeting started, there was a beep which said the session is being recorded. Correct? Everyone heard that? The session is being recorded. So what happens at the end of this session, there will be a video which will be available to the organizers. Correct? Now, can anybody tell me who will have the copyright over that video? Everyone agrees with me? This will be a 2.5, 3-hour session. And at the beginning of the session, there was a beep which said, the session is being recorded. And then at the end, the recorded session, the video would be available, right? Who would have the copyright over that video? The organizers will have the copyright over the video. It's not a very tricky question. It's straightforward. The one who is the producer or who is the organizer will have the copyright over. So the whole idea is, if this session was not being recorded, what I am trying to say, Khushi, if this session which is being recorded was not recorded, then can any copyright exist? The answer is no. Because what we have done, we have fixed the session, we have fixed the record. So that recording is what? Fixation of the conversation happening between you and me. Right? Similarly, say for that matter, you are able to, click a photograph, right? Of, say for that matter, any natural scenery photograph. So what you have done, that natural beauty scenery, you have fixed in form of a photograph. That is what is fixation. Now this fixation, how this fixation would change. So let me give you an example. There was a rock star band, and this person, what he used to do, used to put 3 black lines on his face, right? 3 black lines on his face, something like a tattoo, temporary tattoo, not a permanent tattoo, or something like, like cricketers, they put, right? So 3 black lines on their face. And later on, somebody else started using those 3 black lines on the face. So this singer, what he did, he went to court and said that this is my copyright. I use it. I am the first one. So the court said, what you're using is not fixed. It's transient. The tattoo, the way pattern you put the tattoo is not fixed. What it is transient. Means, suppose in the night, if I wash my face, the tattoo will go. It's temporary. It's not permanent. So what is there? It was not fixed. So no copyright. For copyright purpose, you need fixation. Did we pick it up, Khushi? And for others as well. I hope everyone was able to appreciate what is the meaning of fixation. So fixation is fixing in any way. in form of photograph, in form of video, or for that matter, you would be very surprised. The Act is of 1957, although it has been amended several times, but it says fixation based on any of technology which exists right now or technology which can come in the future, right? So fixation could be through any means, but fixation is required because fixation means fixing it. Whatever you're claiming copyright, it has to be fixed. So say for that matter, you are able to see my slides, so I fixed it. It would not change every moment. It will be same, and therefore I hold copyright over my slides, like the organizers hold copyright over the video, right?